Yeah, David Abbott, this is Brian Groff, and yep, been there.
So what do you think we should do?
Well, in appraisals and in the best advice that I've come across is in USPAP and in doing mineral valuations and really even in stating resource and reserve estimates that we try and keep an unbiased and independent report. Certainly, I have those clients that want a more favorable spin on it, and I've refused to do it. And sometimes it's cost me the client. You know, they've gone elsewhere, but our job is to deliver within our scope of work, and our assignment is to deliver unbiased and independent results. And if we can't do that, then we're no longer unbiased or independent. So I've had to refuse some clients on that.
Thank you. That's very true on both the valuation and then sometimes you have those disputes within an organization or say between the consultant and the company. You're all looking at the same data and your professional interpretations differ somewhat. And the fact that they differ is not unethical. It's how you resolve what the conclusion is going to be. And then what, if anything, the company is going to say about the conclusion.
Donald Cameron says accommodative, reasonable, otherwise tell the client to pound sand.
Okay.
And Jeff Parsley says more times than I can count.
Yeah, it's not all that uncommon.
David, this is Jeff Parsley. When I said that, often it isn't so much that they want you to flat out change what you said and actually change the facts, but it's they want to they try and modify your report language in such a way that it puts a spin on it that doesn't, particularly when it's negative information, that it doesn't necessarily look so bad. And they're not necessarily asking you to change the facts, they're asking you to change your language. We tend to write very directly and they want to put words around it, so it makes it sound like maybe it's not quite so bad.
Yes. And sometimes you can let them, and sometimes as Don said, pound sand. Depends on how broad, how wide the gap between your opinion and their opinion is. So it's the kind of thing where one of the things you can always do is that if you, of course, you have your report that says what it says, and you have your language in there, but somebody goes ahead and writes a press release that says something different. You can always write the company a note and say, we disagree with that press release for A, B, and C reasons. That gets it in the file, and should the lawyers ever come looking through the files to see what was going on, your opinion is then stated pretty clearly therein. Of course, if it's really bad, why you may have the obligation to go talk to a securities regulator and say, oops, these people are going way beyond the pale. And usually it's pretty clear when that sort of thing happens. You think about, the reserve resource classifications and, when does one grade in it? As a practical matter, there's usually a big gap between measured and indicated and inferred. That there's not an overlapping gray area in most cases. I mean, logically, you should think there's some, but practically, there really isn't that. Though in the Pretium Resources case with the Brucejack deposit, you had Strathcona Mineral Resources and one of the other big Canadian well-known consultants. And they've been working together, and we had this gold deposit, everybody, a nice gold deposit, and sort of the background looking at an open pit. They were talking about 10, 12 grams per ton. But then they found these high grades. There were a not insignificant number of samples where the assays were coming back in kilograms per ton. And trying to figure out how you deal with that geostatistically is not easy. And Strathcona finally decided that they simply didn't think that you could make a resource estimate, and therefore that Pretium's having released some resource estimate, and we're thinking about some reserves. I said, wait a minute, you can't do that if you can't make a resource estimate. Strathcona dropped out. When that was announced, the price of Pretium stock fell about 50% over a month. They stuck to their guns. They kept drilling. Obviously, the fact that Strathcona dropped out is a material event, like what we saw with the stock price. But it doesn't mean that either company was committing fraud, particularly. It's just we had this big difference of opinion of what to do with these unusual assays.
David, Brian Groff also had a comment. As an employee, you must assess the personal liability to you.
As an employee?
Yes.
Brian, can you say a little more about what you're getting at? Unmuting.
Brian?
Well, I made the comment. I was having a thought, but I can't remember what I was thinking at the time I made the comment.
Yeah. And certainly, we've all had the thing within our companies and consulting groups where we have differences of opinion within the group that's working on a project. And, compromising or coming to conclusions on how you word something is sometimes can get a little heated, and sometimes you disagree with it, but the person in charge eventually is the one that makes the decision, and that's it. And I suppose we can make our own notes as to what we thought of the decision at the time, but you have to sort of keep on going, and hopefully you can respect each other enough to come up with reasonable compromises. And the nice thing about English is that there are lots and lots of words that mean similar things that help you shade meanings.
Also, Donald Cameron has a comment. Donald, do you want to go ahead and unmute and talk about it?
Well, I don't think it's really within the scope of the discussion, but, you know, Pretium has had one resource revision after another. I think the last report that I read is that they not only lowered the resource from 18 grams a ton down to 12, but now they put a 35% call factor on the production for reserves. I mean, it's a disaster. And it's, I think when you have one of that magnitude and over that period of time, I think there's some questions about how our ethical standards have kept that company out of trouble or kept the investors from losing a lot of money.
I'll have to admit that I looked at that primarily when they were first doing the initial estimates. This is several years ago. I haven't followed what's happened since. Though the question is, and maybe you look at it, how the heck do you do you separate out the area of influence of the kilograms per ton assays from the grams per ton assays? They're both legitimate assays. Nobody's questioning that they're there. You can't ignore the high grade, but you don't want to overvalue the high grade. And what the recoveries are, not an easy problem.
Okay, that's all we have for now, David.
Okay, let's see here. Okay, qualified versus competent. And actually, the lawyer colleague that came this from was, oh God, Stan, yeah. The guy in 3 years was the head of Royal Gold. Name's Scripture, I thought. But you know, who was a mining lawyer, and this was, you can tell how old it was by the remarks. Yeah, Stan Dempsey Senior, and he says, "Look, I'm a lawyer, so I'm technically qualified to represent O.J. Simpson, but I'm not a criminal defense lawyer, so I'm not competent to do so." And so it's a question, even when we come up with our, we're doing a competent person or a qualified person report, and even though we can say, you know, gee, I'm, you know, competent to do part of it, but not competent to do all of it, then where those issues come up. And so this next slide gets into the specifics of this. Of a situation where you may be competent, but not the other way around. And so this is one that I was involved with a number of years ago, where a company had leased a bunch of an owned property up in Maine, and had leased out part of that property because it contained tourmaline-bearing pegmatites. And they wanted to terminate the lease. The leaseholder was claiming that he was being denied millions of dollars of value in the lease termination, and it wasn't valid. So the question is, what sort of competencies are required to render an opinion on the validity of a reserve valuation on this tourmaline property? Anybody gotten into valuing semi-precious gems?
No comments, David.
Well, as I say, okay, as I say, this is a project that I handled, and my assignment was to look at the lessor's valuation report that was claiming the value of all these tourmalines. And I'll readily admit that if you gave me a coffee can full of tourmaline crystals, I could say, yeah, those are tourmaline crystals, but I couldn't give you a market price for them. But I did read the report, and I do know something about what should be in a reserve report, evaluation report. And one of the basic things that you need is carats per ton. In the case of semi-precious gems, why carats is the unit of interest. And there was absolutely nothing in the this report that talked about how much tourmaline you could get out of a ton of pegmatite. And in fact, I looked at the literature available at the time, and you had two kinds of literature on semi-precious gems. One was the mineralogic literature that were all concerned about, crystal faces and, all that real detailed mineralogic stuff. And then there were more general papers on the geology that said, gee, we had zone pegmatites. But nobody ever talked about, okay, in a zone pegmatite, this is where you get the tourmaline, and this is where you get the, the amethyst or whatever else you're getting in the Nagan thing. That's changed a little bit, but in more recent time. But this, in order to come up with a valuation or reserve or resource, you have to have a value per ton. It wasn't there, so I said, look, that's a fundamental thing. It's in any report. I'm perfectly competent to say this is not a legitimate report because it doesn't have these value per ton numbers in it. And so while I admit I can't value tourmalines per se, I do know what should be in a reserve report and can say this rather important piece of it wasn't there. And, that's what I wrote up in the opinion I submitted to the court in this case. Okay, here's one of the specialized knowledge. And so we have MMSA saying, okay, we shall build our reputations on merit and not compete unfairly. And so should a firm excuse itself from bidding on a job for which it in fact has unique site-specific information that is not necessarily known by other bidders and thus gives the firm a business advantage? Is that if the firm bids, are they doing so unfairly? Come on, you folks who respond to RFPs.
And no comments at this time, David.
Oh, come on. We all know that one of the lines in your report is, our firm is uniquely qualified to do. That's sort of like the end of the report is, we recommend you do more work.
Okay, I do have a couple of comments now. Walter Weinig says, having unique experience isn't unfair. And Brian Goff doesn't think it's unfair either.
Yeah.
And the incumbent always has an advantage, but it's certainly not unfair.
Yeah, and it's a something that comes up in the actually the situation came up from my wife's in the software business, And this is something that she saw coming up in the work she was doing in terms of qualified people who were bidding in on software projects. But
Yeah, Jeff Parsley says using unique experience for the benefit of a client is not unfair. And Lori says sometimes the RFP is written so that a specific company can win the reward.
yeah, in other words, when you're drafting RFPs, and I remember doing this when I worked for the SEC, and you had a bias in the government that thou shalt award the contract to the lowest bidder. And so you had to be real careful about writing the RFP's qualifications section so that the bidders all were qualified and competent to do the job, and then you can say, okay, I'll get the lowest bid. But part of it's specifying that you have people that know what the heck they're doing.
Okay, no more comments at this time.
Okay.
Oh, well, wait, there is one more from Walter. The RFP issuer may have an unfair selection process, but that isn't on the bidders.
True, and again, part of writing the RFP is, are you allowing all the qualified people to participate? Or are you being overly stuff? And I remember writing around the proposal where looking for qualifications for a geologist. I was hiring one at the SEC, and so he said, able to go underground and climb up and down little rickety ladders. That basically was saying that people who are physically disabled maybe would not be qualified, because you did have to go out and look at properties periodically. So it was something that the job did demand. But yeah, these could be tricky. Okay, this is going into a series of slides that are more of a standard lecture. And so one of the points that Bernard Gert makes in his Common Morality, Deciding What to Do, is that moral or ethical analysis cannot decide all ethical or moral questions, because different people give different weights to various morally or ethically desirable principles. And the result is that people can have very strong opinions on opposite sides that are well-based and thoughtfully considered. And so things are in conflict. Capital punishment is an example of this kind of moral or ethical question. I like, by the way, Bert's Common Morality is a wonderful short little book that's basic introduction to the subject of morals and ethics.
Yeah, David, there is another comment on the previous slide. Alistair says, reverse question, can you describe a situation in which you believe a bidder would compete unfairly? The bidder is going to compete unfairly.
I don't have one in specific, though I guess this is the to some extent you see in the industrial business where you have the monopolies, or but where you have one company that's really can control the product in a big way, like Church and Dwight and Arm and Hammer with the baking soda business. They make baking soda out of Trona and such things. And so you want to get into the baking soda market, you've got to be able to price compete against Church and Dwight, who can perhaps not quite willing to drop prices in order to make life difficult to you, and you're trying to get your baking soda from the Trona and the Piceance Basin. And so this sort of monopoly, oligopoly, or reverse sort of thing is where you may get into trouble with those.
There's a couple more comments. Walter Weinig says FCPA related issues, personal non-business related relationships. And then Lori also has some comments. Walter, do you want to expand on what your comment is about? You can unmute yourself.
Yeah, as soon as I find the unmute button.
Right.
No, I'm just thinking, Foreign Corrupt Practices Act, there's a whole set of things there competing unfairly with respect to, gifts and bribes and all that kind of stuff. And then there's the situation, my wife runs the company putting out the RFP. Is it unfair for me to bid on it? And, that maybe is a little bit gray. Is that unfair for me as a bidder, or is that unfair for her as the RFP issuer to consider that relationship? So there's some areas like that I could imagine might be where you could see that the bidder is competing unfairly as opposed to the issuer evaluating unfairly.
Yeah, thank you. We'll get into bribes a little bit later. On the RFP, again, when I was working for the SEC, because I could read blueprints, I became the office space cadet. And so when they're moving the office, I get involved in all the things of looking at new office space and then looking at movers. And in one of these moves, I have a brother-in-law who has a moving company, and invited him to bid on moving the office. He's certainly capable of doing that, but while we solicited the bids from interested moving companies, the people who made the decision on who got the bid were in Washington, not in Denver. And so that the independence was made that way, and the fact that I started to say, hey, look, this guy is my brother-in-law. And in fact, he did get won the job and did a very good job for us. But that's, a conflict of interest came up, and it's a matter of disclosure and, what you need to do to assure everybody that conflict is not a problem. Conflicts of interest are perhaps one of the most common ethical issues that come up in professional practice.
Okay, we have another comment. This is from Lori. When a company sells equipment, sells engineering services, etc., an example, when the engineering company is hired by the client to review all the bids, technical bid analysis, and they are one of the bidders for selling their equipment. So that's another conflict.
Yeah. We have a machine that is particularly suited to dealing with your rock sort of thing, which may or may not be true. Specialized on it. Okay, on to this business of conflicts between ethical concepts. Well, within the geosciences, we've got two fundamental principles. One is the protection of the public's health, safety, and welfare, short and public protection. And the other is maintaining the confidentiality of employer clients' confidential information. And so what happens when these two provisions come into conflict? And what's interesting is I just got from a friend of mine some articles from the I think it was, the Professional Engineers of Ontario monthly magazine had some things on this business of public protection and whistleblowing.
Okay, there's a comment from Francisco. RFP that promotes certain oligopoly or monopoly is a fault of the issuer, not of the bidder. In those cases, is against the law, thus not ethical.
Well, to some extent, sometimes the question there, and again, this is the sort of thing that can come up in the industrial minerals business, where you've got one fairly unique deposit, and the fact that one company has the right to extract it gives you effectively a monopoly, but it's not the old Standard Oil sort of monopoly. It's just, you want this particular mineral product, it's got to come out of this particular property. So that there are some cases, admittedly few and far between, where we're not talking about an antitrust act kind of problem. But again, it's a sort of, as I say, it comes up more often than that. But you remember back in the 50s and early 60s, the price of molybdenum was quoted FOB climax. Climax produced most of the molybdenite. And it wasn't. That was just, you're going to sell molybdenum from porphyry copper down in Arizona by, you had to beat AMAX's price of FOB climax. Okay. Whoops, I got ahead of myself. So the MMSA ethical guidelines specify that the responsibility for the protection of the public's health, safety, and welfare at all times should come before responsibility to the profession, sectional or private interests, or to other members. And so the interpretation of this clause of the principle is the interests of the community have priority, and so a member shall avoid assignments that create a conflict between the interests of his client and the public interest, working conformity with acceptable technological standards, maintain essential services, promote the well-being of the community. And if his or her judgment is overruled in this matter, they should inform their client or employer of the possible consequences if that action is taken, and if appropriate, notify proper authority. And so basically this is saying that if your company is not following the accepted plans for environmental mitigation on a project, or you're about to lose your tailings dam or whatever, you need to let the first of all, encourage your employer or client to correct the situation or let people know about it. And part of the problem becomes when, how bad is the problem and how imminent is the problem. And so you have time to work with people on some of these things. And so, but the letting the regulator know is where we get into the tattletale or whistleblowing. And of course, we all learned the don't tattletale rule in Sandbox. And that really was how we learned to get along with our peers and accept responsibility for our own actions without having to go run to mommy or the teacher or whomever. But the problem with no tattletale is that it can cause us to either embed our immoral or unethical acts by not blowing the whistle. And so some examples are, the 1986 launch of the Challenger, due to the lower temperature, but there's the whole, but there's this teacher in space launch who got every kid in the country, or at least elementary school kid in the country watching this launch. What do you mean we scrap it? Yes, it certainly was a educational launch, but not the one that everybody wanted. The ignition switch problem that General Motor was having, that some of their engineers had known about for years. Volkswagen's fake diesel tests. When the Flint, Michigan water crisis came up, I didn't realize how many people were still using lead supply pipes on their, for the water mains into the house. And I guess it's even in the older homes in Denver, I thought everybody had been using copper for a long time on the supply side of things. And it's not true. And if you change the pH or something slightly, all of a sudden that lead can start solubilizing. And there actually is a problem in Denver where there are homes and buildings that have lead supply lines. We had the Gold King mine spill where, if you looked at the professional papers on the mines down there, you can see the cross sections where the mines are all interconnected. And so you go blow out the plug on the mine that's lowest in the system, but you're going to have a heck of a flood in the head. There's no big surprise to people that know about mining. Why the EPA had these people go in there with your front end loader or whatever and haul this stuff out. And then all of a sudden we're flushing all that stuff into the Animas River. So, and part of what we're getting at is integrity. And Carter has a wonderful book on integrity. It's very readable. It says it involves 3 steps. First off, you have to discern what's right and what's wrong. Understand or that. 2, you have to act on what you've discerned, even at personal cost. And so integrity is doing what you think is right, even when you're going to get dinged for it. And saying openly that you're acting on your understanding of right from wrong. As I said, you got to cheat on your income taxes, today being tax day. If you feel that the amount of your tax that goes to the Defense Department is immoral, So you're not going to deduct that percentage from the amount of taxes you owe. You know, but what you really need to do if you're acting with integrity is you're telling the IRS that you're withholding that amount of the money. So if they know right from the beginning that you're doing that and you're willing to take the consequences. So whistleblowing requires this kind of integrity. And how you do the whistleblowing can certainly affect how the consequences come down. Ibsen's Enemy of the People is, first of all, you can find it on the web if you don't have a copy, but the story concerns a small town, a doctor in a small southern Norwegian town who discovers that the town's spa, which is its economic basis, is polluted. And when he makes this known to people, why all the people in the town ostracize him because it's putting them out of business. And initially I thought, well, that's too bad, but his wife's family had money, so the fact that he wasn't getting medical practice wasn't so bad. And then we discovered that the source of the pollution is his father-in-law's paper mill. So it's an interesting case history if you want to read. And you know, we have the sort of reverse here. We have some of the environmental groups that keep complaining that, you know, whatever we're going to do is going to cause problems, and it just sort of flips things. And let's face it, mining is going to cause environmental degradation of some sort. But if we want the mineral products, which we do, we're going to have to put up with them. And finding the balance there is a real ethical situation. And the common thought of, oh, we're going to do us sustainably, when most people think that sustainable means you can keep an operation indefinitely, doesn't work for mineral deposits that are depletable. And I think we need to, as an industry, make clear to the public what sustainable mining really is. That you want the minerals, and we all do, then you're going to have to put up with a certain amount of environmental degradation someplace. Doesn't mean we can't talk about it, but it does mean that let's be real about what's going on. Okay, coming into a real case from a while ago. We had the SEC sued Rio Tinto, its former CEO and CFO, for failing to disclose the delays, setbacks, and rapid decline in the value of the coal in Mozambique that it acquired in April 2011 for $3.7 billion. The former CEO and CFO kept increasingly negative information about these coal assets from the board of directors, from the audit committee, the independent auditors, and the investing public. Finally, in May of 2012, the Mozambique people, part of the company, said, instead of being worth, this is $3.7 billion, it's worth a negative $680 million. And it wasn't until the end of the year that the Mozambique people in coal realized that the failure to properly disclose all this was not getting past the CEO and CFO, and so they finally went to the chairman of the board and said, "Are you aware of this?" And the chairman of the board said, "Oops." And so they fired the CFO and the CEO, and subsequently why the SEC sued over this failure to report. And
David, there's a comment from Debbie Strusacker, and she says the federal and state laws, and I think she's talking about the previous slide, the federal and state laws governing mining authorize the degradation. Environmental impacts must be minimized, but there are no statutory or regulatory requirements to avoid all impacts. That would make mining impossible.
Agreed. Of course, there are those that want to go for zero impact, and that's where our education, and Debbie's been doing that for years, of trying to educate people. Thank you, Deb.
Well, thank you. I guess the point I was trying to raise is that you don't have to concede, well, you need the stuff, so you have to put up with us. I mean, I think it's a far stronger position to say that what we're doing is authorized by state and federal law. And we take a lot of, make a lot of efforts to minimize our impacts, but the impacts that we do have are accepted in these laws and regulations. And just like anything else that we do, whether it's drive on a highway or build a house or take a trip, I mean, there are impacts, and the impacts from mining are known, and generally speaking, and there are regulations in place to regulate those impacts, and to, and for regulations for financial assurance as well, so that if there are impacts, they get reclaimed. So I just think it's probably not useful just to sort of say, well, yeah, we create these impacts, but you need this copper or this gold or silver, so you have to put up with it.
Okay. Good point. They say we need to talk about what the impacts are and what is acceptable in terms of mitigation, and still allows the deposit to be extracted.
Well, and that's usually the focus of the permitting process. And so all of those impacts, in EIS documents and other permitting documents are disclosed to the public.
Yeah. And how you do it so that the fanatics on one side or the other don't dominate the situation. And we've been doing that for years. So thank you. Okay, going back to Mozambique. My things here is that one of these Mozambique coal executives that helped blow the whistle on this was a geologist, I'm sure. But I think here we had the non-disclosure because the people at the company said, hey, we have a problem, and jumped the chain of command level. I think helped certainly at least some of the impact of the company. I mean, Rio Tinto was one of the named defendants in these lawsuits. But the fact that the announcement that there was a problem came from the company helps. And so they, at the end of the day, why their $3 billion asset was sold for $50 million. And the lawsuits remain. I periodically try and check and see if there's any resolution of them. I have yet to see it. So here we have CJ's an environmental geologist hired by one of the larger mining companies. to work on a project in a foreign country. And the company's website talks about how they're committed to environmental responsibility and, what a good company it was to work for. And as part of this particular project where the company had agreed to take a number of mitigation actions to avoid various kinds of degradation. But after a few weeks on site, CJ realizes that the promised mitigation actions are not being implemented. So what should she do? See, whatever gender CJ is, doesn't make any difference. Debbie, you have any thoughts?
Well, I think, at least initially, CJ should go to his or her immediate supervisor and, discuss what's going on and try to resolve it internally with the company. I guess also if I were in CJ's shoes, my level of concern would be guided somewhat by whether this was, an environmental problem that actually was serious and had the potential to affect people, or whether it was more of a lack of a regulatory compliance issue.
Yeah, well, the degree of impact and its probability of impact are certainly part of these kinds of considerations. In other words, can you switch gears and avoid the problem, or is the dam going to fail tomorrow, kind of thing?
Yeah, and we have two others who agree with bringing it to the attention of the supervisor and start within the chain of command. Thanks, Mark and Walter.
Okay, and when the chain of command doesn't work, what happens?
Patrick says put it in writing.
To whom?
Marco says review the detailed information about the mitigation plan and understand why it's not been implemented.
Yeah, I agree. You want to have a good report of what was supposed to be done, what wasn't done, what's happening as a result, and so on. But whom, if the company won't change what it's doing, to whom should you complain?
Debbie, do you have another comment?
Well, yeah, I mean, I guess, again, if assuming the mitigation plan is part of a permit, then you've got a couple of things to consider. You're out of compliance with your permit if you're not following the plan, and that's a serious problem. And usually my experience would be maybe your immediate supervisor is, not sophisticated enough to understand the problems there, but somebody in the company certainly is. I mean, is there a chief legal officer or somebody else you could go to and raise this compliance issue? And of course, I guess there are always concerns about, well, this is not maybe a job enhancing move, but if the problem is something where the environment is being seriously degraded or it puts people or a community at risk, then you do have an obligation to try to figure out who to talk to. And I would try to do it within the company to the maximum extent possible. If there were really serious risk involved, then you would give thought to contacting the applicable regulatory agency.
Yeah, I mean, eventually the regulatory agency may need people contacted. And most regulatory agencies, when they get in enforcement mode, that's done confidentially. In other words, it's far more reasonable to go to the regulatory agency who, one, have some technical knowledge of what the heck's going on and what the situation is, The last person you want to go to is the local news reporter.
Oh, I
'Cause
would never do
then,
that.
yeah, going to the newspaper is not a good move.
Now, we have several other comments on this. One is try to determine the root cause and develop corrective actions. And that's from George Sturgis. Mark Bowron, in keeping with the first slide, is there an obligation to the shareholders? And Walter says, if you are knowingly out of compliance and fail to report, there may be personal criminal liability involved. And Tom Aldrich says, get companies often have internal telephone number to report these type of things. So do any of you all want to make any more comments about that?
Yeah, I guess the specific underlying case that I wrote this off of, it was pretty clear that at least the systematic approach by the project management people was to ignore what they were supposed to have been done by their permit. And eventually the fact was that the regulatory people recognized that the permit was not being complied with and the project was shut down. And some of what's going on here is we had a company, again, it was a big mining company, that was saying, gee, we really like this. And here you have CJ, so, junior to mid-level person, and says, gee, I really, it's a great opportunity to go to work for these people, and finds out that it's not such a wonderful place to be. Needing to go to blow the whistle on a regular, why, as I say, the matter of integrity is, if you lose your job, why, it may be hard to pay the mortgage and, keep the kids fed and in school. So there really are consequences. And that, here we had, at least on the project level, a systematic ignoring of what was going on. It wasn't just one or two people.
Okay, David,
So
we have a little bit less than 10 minutes left.
yeah. Any more on this one?
I don't have any more comments. Oh,
Okay. Did we get one?
no, I read them all.
Okay. Here we have the not uncommon sort of thing that you're involved in a lawsuit, you're an expert witness. The suit is settled by consent, which includes a gag order on talking about it. But the GSISS case, I believe, is a pollution case, that others would be harmed if his opinion were not made public. And so if he really is a party to the gag order, can he disclose his opinion? And if he does, what's the consequence?
No comments so far.
We've seen one of the things I think is happening these days is as a result of the Me Too movement, there have been a number of women who have been part of negotiated settlements that they were compensated as part of the settlement, but then couldn't talk about what they talk about the case. And so we've had people come in and start negating those gag orders as being something that simply is protecting people who are acting illegally. And so I think it's going to be interesting to see just how much, you know, there are going to be instances where we say, okay, this gag order in effect allows somebody to continue with illegal activity. And so if you go ahead and violate the gag order, yeah, the judge can put you in jail, but you say, you know, I'm going to jail because I told the general public about this pollution plume that I studied about. And so, you know, that the you know, maybe that's the time when you talk to the reporter, because the judge isn't going to like seeing his name in the paper as being supporting the polluting people.
Yeah, Brian suggests that the geoscientists should work through their attorney. And then
Yeah.
Walter Weinig says one interpretation of the gag order is that the judge and both parties to the lawsuit believe the community is better served by not airing the geoscientist's opinion. And Debbie says, are you drawing a distinction between a gag order and an NDA as a contractual obligation?
Actually, I wouldn't. I mean, an NDA is a different sort of thing, but again, if you become aware of something, and so you're with an NDA, you have to go to the client or whoever, the employer, and say, hey, look, we need to do something about this. And our ethical MMSA, and it's true of just about every other geoscience ethics code I've looked at, with the exception of AAPG, which did have it and then took it out, is that public protection comes before confidentiality. That's the basic professional ethical rule. There may be consequences for following it, but so with gag order or MDA, same. There may be times you need to disclose.
Okay, David, we have about 4 minutes left. Do you want to wrap up?
Okay. Yeah. First of all, have you enjoyed this? As I say, we've had a little bit of disconnect in terms of, you know, seeing people's hands up so that we can get all the discussion about a particular slide finished or go on the next one. But has this been a useful format for you, and have you learned something? Is it something we should do again in the same way?
Yeah, I think what we can do is I'll just send out a little questionnaire to everybody and get some feedback that way. I did also record most of the session. Unfortunately, I kind of spaced out starting it at the beginning, but we got most of it, and we'll be posting it on our website. So I'll let you all know about that as well. Also, all of the chat questions will be posted as well. So we do appreciate all of you all coming. And we have a couple more comments. One from Marco. He says, I think the gag order is law, so you can't disclose his opinion. And then Francisco has a question. If the gag order is given by the judge, isn't he responsible for the public effect? So that's a couple more things. We have a couple minutes if you want to address that.
You know, and again, this is something that you want to consult with an attorney before you do anything, so you realize just what the consequences may be. But as I say, I think that to some extent, what's been happening with these Me Too movement and non-disclosure agreements, I'm beginning to wonder if they'll change. It's like one of the things that happened with in the software industry was for a long time why people would write non-compete clauses for all the software writers, and which would say, gee, they couldn't move from one company to the next. And the pretty quick people started suing and says, you can't enforce your non-compete clause unless you pay me for not working for 3 years or 5 years or however long the non-compete clauses. And if you're not compensating me properly, why, it's a form of slavery. So they're bringing in a different angle on the non-compete clauses that used to be fairly common, have been vastly changed as a result of what happened in the software industry. And I think I'm wondering if the same thing is going to start happening with these gag order non-disclosure agreements settling lawsuits. This we'll have to see, but it's certainly, I think, a place where the approach is going to change.
Okay, David, our time is up, and thank you everybody for showing up. We really appreciate it. And we do have another webinar coming up in August. That one is about critical mineral supply chain. So you've probably seen that information come out from us, but we will stay in touch, and thank you everybody for showing up.
I certainly want to, what did you think about how the mechanics of how this session went? Because
Yeah, we'll include
whether,
that in the survey.
please respond, because we do want to know. So thank you all very much, and have a pleasant evening.